Welcome back. 3 foreign nationals are fighting to stay in South Africa with their children, despite a breakdown of their marriages. The reality of having to leave the country without their kids sparked a class action suit against the Home Affairs Department. The Immigration Act doesn't provide a visa for foreign nationals who are primary caregivers or single in cases of spousal separations. Gary Eisenber is the immigration attorney leading this lawsuit, and he joins us now. Thanks very much, Gary, for your time. So these parents are not South Africans. They are or were married to South Africans. And when they're told to leave the country after the dissolution of their marriages, they must do so without their children. But these are not new circumstances. Is this the first time South Africa's immigration laws have been challenged in this regard?
Yes, it is, surprisingly. And I've been practicing immigration law for the last 24 years. And 20 years ago, about 2 decades ago, we had a troika of constitutional court judgments protecting the rights of spouses to reside together, foreign spouses to reside together. And that gave rise to what we call today a spousal visa. And what we didn't have an opportunity to do, is find the perfect set of circumstances to challenge the act, to provide for these parental visas after these spousal relationships have broken down, and leaving children uncared for, South African citizen minor children uncared for. And that's been a lacuna in our law, which has prompted vicious custodial battles over children and relocation applications, where the foreign parent, more often than not, has been made to leave the country with or without their minor children. And this has been a travesty of justice that has never been cured until hopefully soon in the High Court.
So challenging immigration law seems like a mammoth task, and court processes, especially under COVID, take time. What are the reasonable prospects of success for these parents?
Well, if you just imagine what a reasonable judge would say, given the facts as they've been explicated in our papers, we expect the judge to agree with us that there is a dramatic, unconstitutional lacuna in our Immigration Act that needs to be filled by allowing foreign parents the rights to fulfill their parental duties to their children on the basis that children, minor children, have the right to parental care, and that the government must take into consideration the best interest of children when deciding to grant the foreign parent a visa. The point over here is there's no visa to grant yet. Our Immigration Act doesn't make any provision for such visas, so we are trying to carve a visa out of our immigration legislation.
Gary, so this situation is also quite complex. The names of these applicants and their children have, of course, not been made public to protect the identities of the children. We understand that in certain circumstances, the marriage of the breakdown is due to abuse, where children would not be safe with the South African parent should they remain without the foreign parent. What happens to these families while the law takes its course?
Well, in this case, we can't speak generally, because this is the one and only case. But what has happened here, and I will be very careful in what I'm going to tell you, we received from the State Attorney, and the State Attorney's Office, of course, represents state parties, the respondents in cases like this, and this case was launched in February. Now, we have no notice of opposition. We have an email from the State Attorney's Office giving us an assurance that although all of these 3 foreign parents are here in South Africa illegally, that they are protected and that they can continue working to provide for their children without a visa being in place and without us receiving a final favorable judgment. But what has happened, which has unfortunately delayed the case, is that the State Attorney in July withdrew. So as we have it, the Minister of Home Affairs, the Director General of the Department of Home Affairs, and the department itself are all 3 respondents in this case. They are without any legal representation at this point. And this is something which is more or less historically unprecedented. So it's not something that I can make generalized comments about it, but this is where we are. And of course, that has to be cured too. We're waiting for a letter from some other law firm who will take on a representation of these respondents. But this is something that is unprecedented. This never happens. And this has a remarkable impact on the continuation of this case.
Absolutely. Thank you very much for those insights. Immigration attorney Gary Eisenber, and certainly the hope is there that those parents will be allowed to remain with their children until a decision is made.